The CPI report, Child Protection in Iowa, brought to you by Vocal Victims of Child Abuse Laws. You can watch our program here on Mediacom Channel 15, Sunday afternoon at 1 o'clock. Again, it's aired on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. You can also give us a call, parents that are having problems with the DHS, lost your children or whatever. We'll give you some tips. My number here in Des Moines is 515-276-3956. John's number is area code 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa. And there's a few things when this program airs, it'll air on both sides of the voting booth. One will be Sunday before the Tuesday vote, and one will be Wednesday after the Tuesday vote. So we're not really sure whether to congratulate the winners of the in the judicial race, or what to say, vote for or against these judges. We do know that there are 85 candidates for judicial positions. They now hold judicial positions, and they like to hold those judicial positions next year. In fact, they get to hold them somewhere between 4 and 6 years between retention votes. If you know of good reasons to keep them, I would suggest that you vote yes on the judges. However, if you do not have that substantial information to regarding these candidates, I think I would find something else to do with them instead of voting yes. It is your duty to vote yes or no with respect to retaining the judges. Here are some of those judges. You may have a few more sticking around there somewhere, Don. But Elisa Ofram, Donna Paulson, Artis Reese in District 5. Associate judges include Gregory Brandt, Carol Coppola, Carol Egley, Louise Jacobs, and William Price. Congratulations to those who made it through by the skin of your teeth. If you happen to be watching this program on Wednesday, any other judges there available?
And you forgot to say good riddance to the ones that did make it through.
Okay. Hope you like your new job.
Yeah.
Okay. Here's a few more. Thank you, Don. Daryl Goodhue, Peter Keller, Richard Clogg, Virginia Cobe, Thomas Mott, Kevin Parker, Elisa Overham. Oh, we've already had Elisa Overham on here before, so maybe we're doing our list over again. Yeah. So those are the ones who are running in District 5. Now, these people have had a good opportunity to let us know what they're all about. It's not the same kind of thing as running for an office, but at least we do get an opportunity to show them the door after they have been selected by a special interest group called the Iowa Bar Association, and specifically set up for retention or for candidacy and placement at the bar by our governor. So you talk about special interest. Well, I think the Bar Association is a special interest group. Something like 1,600 lawyers in Polk County. Something like a little over 1,400 of them practice law in Des Moines. So that's a lot of lawyers, and they need lots and lots of things to do, and they may be able to manipulate things so that they can uh, survive. After all, when there's 1,600 of them to do the legal work for Polk County, each of them needs a good-sized piece of the action in order to keep uh, bread on the table, in order to find soup to feed the kids. So, so that's the situation about judges. Congratulations if you made it through. You're listening to this on Wednesday, and it's all done and over with. Uh, and hope you enjoy your new jobs for those judges that didn't quite squeak through the retention. Well, it's almost a foregone conclusion that judges will win their retention because people are not totally informed. And that's my reason for voting no, because they had a chance to inform the public about their doings, but all of the 5th District candidates for retention refused to use this opportunity to let people know what they're all about. And they call that judicial independence. If your child says he wants to be independent and he's only 2.5 years old, you frown on that, don't you? You say, well, no, I'm not going to give you independence. You're going to follow a few rules around the house, sir. But our judges, for some reason, believe that they're somewhat distinctive in their stature in the whole scheme of things, and that they are somehow special. And I believe to some extent, of judicial independence. In other words, no one should be able to um, manipulate the court system by picketing or by influence of any sort to for a judge to come down with a decision that he wouldn't otherwise come down with, or a decision that is not in keeping with the statutes or with the facts of a specific case. We rely on our judges to be prudent and to stay away from influences of that sort. To that extent, I believe in judicial independence. To say that judicial independence also covers any judge who wants to do what he darn well pleases and nobody can critique him on it, and nobody should ask him, his philosophy or which Supreme Court justice nearly matches his own philosophy, judicial philosophy. What's wrong with that? That doesn't endanger the judge's ability to speak out. Any addition to that, Terrance?
Well, I think that they should share something. I mean, here we're in a society of free man, and these judges have a last say so over conflicts involving our property rights, our liberty rights, and we
And your personal liberty and everything.
personal liberty, everything, and we know little or nothing about these guys or ladies, and I think it's kind of a sham what they put out on the Iowa Supreme Court website, the voter retention guide. It kind of loosely touched on the subject, but we weren't really informed, and we're still not really informed. I think it's high time that they release some information as to the process, that they go. I mean, not only the process, but also the philosophies of each one of these individuals. I mean, because the average voter is not going to get out there and be able to read all these different legal opinions and dissect them and go through them and try to find something of value. I mean, something that's going to pinpoint their philosophy or pinpoint their their thinking, and it's going to be too tough for the average person. But I think that it's oversimplistic for the Supreme Court on their website, the Iowa Supreme Court on their website and their judicial guide, their voter retention guide, to say, well, you could rely on the Bar Association's ratings, because that's, like you said, that's a special interest group. And it's very funny or very contradictory to uphold that special interest group, but at the same time, when people like myself and groups like Jail for Judges are talking about judicial accountability, they're saying, "Oh, well, we shouldn't have judicial accountability. We want to maintain judicial independence. Those people that are calling for judicial accountability are special interest groups." Well, you've got a special interest group that you're referring to try to uphold your position. So, I mean, you've got to be consistent with your stance. Judicial officials who are towing these lines and putting all this stuff out there for us to absorb, so to speak. But I think that it's going to come in a format pretty soon. I think that citizens will get it together. I myself, I've tried to work on some stuff. I've got so busy this summer I wasn't able to put some stuff together. I wanted to put some stuff together online as to that would actually put forth a starting basis anyway for evaluating judges. I think it's a little bit of a tough job to tackle because you do have to have court watchers. You do have to have people that can analyze the various judges' opinions and their temperament or whatnot, and try to place that in a format that's easily discernible. So I mean, it's a huge task to try to tackle, but someone has to do it because it's too important.
Right.
These judges hold too much authority, and because they are immune, that's even a more of a dangerous kind of authority over our property, our liberty, even our children's liberty, for us to not pay attention to that. So, I mean, that's why I'm going to take it upon myself, and, I'm just going to actually, from the judges that I've had bad experiences with, I'm going to just vote no. And I would recommend some of the other people out there that's listening to do that as well.
Only 51% of them have to vote no.
Yeah.
Okay.
Yeah.
The other
Yeah.
49 can be happy with what they get. Did you know that I belong to a special interest group, Terrance? I am a member of a special interest group.
I think we all do.
I am a citizen. The reason why I bring this up is that our Chief Justice, and I trust that she's going in the right direction, but that's one thing that she said about people who are critiquing these judges now. How dare you critique the judges? They're bringing up this survey thing. A group brought up a survey to inquire as to the suitability of some of our judges to serve. And she said that was done by special interest groups. Well, I didn't put together the survey, but I thoroughly agree with the idea that citizens should be informed, and I back the idea of a survey to help us, or to give the judges an opportunity to let us know what they're stuffed with. And
if it's good enough for one special interest group to have a survey, it should be just as good for another special interest group
absolutely.
to have a survey.
You bet.
I think that it's awful. I think that it's blatantly unfair for her to characterize and try to condemn the one group as a special interest group, but trying to uphold the other one. And these are people that we look upon to be fair.
Correct.
Think about it, people. We've got a special interest group that's closely tied to judges, such as a bar association,
Right.
and they're going to uphold that survey. But when we have another group that's a special interest group that's is comprised of citizens that are looking to enhance families, that's something that we should ignore.
You bet.
So we should. I mean, that should be something that we should really look down upon as as a citizenry, when we have a judicial member that's supposed to be fair, that's supposed to understand fairness, saying these kind of things.
You bet. Okay.
And was that turn on us, turn us? Was that her?
Turn us.
Okay, yeah.
Turn us.
Turned on us, turn us. She turned on us again, once again.
You bet. One thing that I was interested in when she talked in the state of the judiciary, or in her one of her opening speeches, anyhow, she said that we're going to look at the child welfare cases no longer as a committee. In other words, we've been doing so much stuff, in staffing, and we did all kinds of silly things in which you have 14 people around the table deciding what's going to happen to your child, and the only one who doesn't get to speak up are the parents. And by the way, they're the only ones who are appearing in court, not being paid. We have all kinds of therapists and specialists and counselors and social workers, residential counselors. We have all kinds of judges and special people who are being paid to take care of your child, to take care of your child's needs.
No, they don't take care of the child's needs.
That's what they're assigned to, though.
They're just spinning their wheels, collecting the money.
Yeah, but it's amazing to me, though, to walk into a juvenile courtroom, though, and see the entire table full of people who are being paid to do all these things. And, of course, everybody has to have their own court-appointed attorney. That way the court can control the attorneys. After all, they're paying for them, and so they can control the attorneys, and that's the right thing to do. Everybody needs legal counsel.
They're paid paper shufflers.
Yeah,
Paid
right.
paper shufflers.
You're right. And they better shuffle the paper correctly, hadn't they?
No, just quit shuffling the papers because the kids fall through the cracks.
And what is the key word that comes when all these people disappear into the back room? What's the next phrase that you hear from them? All parties being in agreement. Of course, you didn't get to go in the back room, so
Wow.
you don't know who the parties were, and you don't know what the agreement was.
Now, if you don't know the legal terminology, that means parents are left in the dark. Your court-appointed attorney goes in the back room. He's paid, right along with the rest of them,
Yeah.
to shuffle papers and chit-chat. And I don't know if they have coffee back in there or whatever, coffee and donuts. But it's sure not in the best interest of the parent. And then 6 months or a year later, you find out what happened, a little bit of what happened in that back room after you lose your children.
And one of the requirements when you go on appeal is for you to say, well, you didn't raise an objection. I didn't know what objection to raise. I didn't know how this decision came about. It all happened in the dark, in the recesses of the judges' chambers, where a lot of things happen that we don't know anything about. Well, the state legislature is going to be meeting. In January, they will convene 100 state representatives when they are chosen next Tuesday. Will meet and for the House of Representatives, and then in the Senate there will be 50 individuals who will show up along with clerks to help them deliberate some of the problems that we have. Now they'll be dealing with all kinds of issues, and some 1,500 cases, 1,500 different bills will be introduced into the House and in the Senate. I have just a few. This ought to keep them busy for the first 2 weeks. We'll come back and talk about these in a little bit, because in a little bit we're going to switch to Terrance Walker. We didn't bother to introduce him because
I don't need an
he's a regular.
introduction.
Needs no introduction. Limit domestic violence and restraining orders. You know, that would cut the court dockets terrifically. How would you do that? Well, number one, you'd charge a filing fee for the grant of orders. Right now, anybody can go in on a domestic violence fee, and if you can find a scratch on your hand or something, and you can blame that on the old cuss, then you can get a restraining order on that person, which means that fella cannot come home to get his pickup or his dog or a blanket to cover him up in the pickup when he sleeps in it overnight. It means all kinds of distress, and the women know it, and they use this technique to do all kinds of fraudulent things. They don't have to sign any affidavit. If they need legal help, they don't have to go to a lawyer like the rest of us schmucks do. They can simply go to the clerk, and the clerk is required by law to help them through their written. I think they do have to swear to it, though, come to think of it. But they, that becomes a court order when it is uttered at the counter. I would require an official sworn affidavit when somebody comes in and says, you know, I got this horrible wound, you know, the size of a cat scratch when I was tussling. Of course, I kicked the living daylights out of hubby, but he turned around and tried to defend himself, and look what I got out of it. Well, these domestic violence cases can be serious, but most of them are not. And they're wasting court's time like crazy. And for some reason, these court officials, when they go into budget hearings and say, for some reason, the number of domestic violence cases that are filed is climbing rapidly, and we need more money. That $124 million you gave us last year isn't sufficient to cover all of the bills that we're incurring in it. So I'd say limit domestic violence and restraining orders. Find ways of weeding out the nonsense. And here's one that you might like, Terrance. Require detailed affidavits and witnesses to any violation of Iowa Code 719.1.
There you go.
Yeah, 719.1 is kind of a catch-all. Says you somehow interfered with the official acts of a policeman or a fireman or nurse or ambulance driver.
Or any peace officer.
Or a peace officer,
by
yeah.
resisting or obstructing them.
Yeah, and I suppose that would be an officer in a school. They have different names for them in school, but they're still uniformed and have the authority to do all kinds of things. Review all laws which have sentence enhancements. In other words, if you have to have this and this and this and this, you know, if it's a theft case and the guy happens to have a stick in his hand, that means 15 years instead of 5. I think that a theft is a theft, and I don't see any problem with having degrees of theft, you know, under $100, over $1,000 and so forth. But to have all these silly enhancements that are just toys for the prosecutor to play with. Charge a minimum of $100 to any DHS worker who engages law enforcement as escorts. You see, they like to bring up law enforcement to the door. It has a tendency to make you think that something serious is happening, instead of just the witch at the door that you know of as you've known before because she's been there before. As a social worker, it puts a little more urgency into your giving attention to it if the highway patrol, a county mountie, or a local police officer is there. Well, I think that for each of those escort missions, if they're important enough to the social worker and she's willing to sign an affidavit swearing that that her life is somehow endangered. And by the way, there was a social worker whose life was endangered down south. The only one that I've heard of in years and years and years and years. In fact, I've never heard of a social worker being harmed going about her duty.
15 years ago, there was a little article in the Des Moines Register paragraph that children were taken from parents, and the social worker ended up dead. So that happens occasionally.
Every 15 years.
Could be, yeah.
Well,
That isn't very often, but kids every day many kids are taken away.
yeah.
It's a wonder that they don't irritate parents a lot more than they do.
You know, I think there are some individuals who have the ability, and I think it could be trained into anybody to sweet talk someone into taking your baby. Simply to explain, these people are abrasive. I don't call them witches because that's my terminology. I call them witches because this is the terminology.
I call them witches with a B.
Okay, right.
And I have a story along that line. But
Oh, do you? Okay.
Yeah, I was going to let you finish, but
Okay.
yeah, the whole incident surrounding my daughter a couple weeks ago, October 12th, when her mother was arrested. She had physical care. We've got joint custody, and the mother was arrested, charged with child endangerment, possession of drug paraphernalia, and some other stuff. The social worker that didn't contact me in regards to that matter basically gave the green light, I guess, somehow to have my daughter put in foster care for 3 days without my knowledge whatsoever. And I've got joint legal custody. So, I mean, this is really, I was just dumbfounded as to why I wasn't even contacted.
The law says
one.
they can do that, doesn't it?
They're supposed to contact you within 24 hours.
Right.
And that wasn't done. The police department, or whomever the arresting officers were, their department had the duty to contact me, and they had supposed to have the assistance of the DHS in locating me. And you know, my daughter knows my phone number by heart. She has for some time. Nobody even asked her. Nobody talked to her about me. So I mean, I filed after going to get my daughter from school the following Monday. About 3 days later, she'd called me, or I actually had found out through her grandparents where she was at. 3 days after the fact, I filed for a custody. I'm still waiting the result of the custody determination. Filed for physical care custody instead of just visitation legal custody. And at the hearing, I was kind of dumbfounded, but lo and behold, the temporary foster care lady shows up. What does she want there? I'm just dumbfounded. And she shows up at the council table with the mother, you know, whom subsequently to getting arrested had gotten out of jail from pretrial release. And I couldn't figure out what the heck is this lady doing there. You know, and she's even coaching the mom and telling her what to say. And, you know, of course, I made my objection. I said, Your Honor, this lady doesn't have any right to be at the council table or the table where the parties are supposed to be. She's not a lawyer, and she's sitting there coaching the witness. I don't have my witness telling me what to say. So he subsequent to that removed her from the table. But, you know, she's just going on and on and on and on and on. How she had come to the school after she found out I was there. Ooh, scary, huh? And I picked up my daughter, and she had to write down the license plate. Okay, what the heck is going on with these people? So, you know, I asked the lady, I said, well, how long have you known my daughter? About 4 days. Do you think that you be in a position of foster care? Do you think you have more natural care and affection, and for for a child, knowing the child for 4 days as opposed to a natural father? Well, no, I don't think I would. Uh, how much do you get paid for a child my daughter's age? About $362.50 a month. And she knew down to the last penny how much she makes. So therein lies her motivation. I'm telling you, folks, do not trust these people with your kids. If you've got rights, legal rights, don't just let these people just trample on your rights. Go get your kids. They shouldn't have them for over 24 hours. The law says that they can't have them for 24 hours. If a situation occurs, you can file a civil rights lawsuit. I plan on it. I seen somebody else did it not too long ago as well. I think there was one filed about 2 years ago when the law was first enacted. Guy sued and because they kept his kids for 18 days, man. It was just crazy. It's kind of a similar situation, but it's crazy. But you know, the audacity of the lady to show up there and to push for something, knowing that the foster care system was not even supposed to, for one, be involved in the first place, knowing that there was another joint legal custodian. For two, she cannot show up in the picture afterwards because this was a custody hearing between the dad and the mom. This had nothing to do with foster care. There was no legal order putting my daughter in foster care, and she could not point to anything. So I hope Judge Baker makes the right decision, because if not, I'm going to be on here next time bad-mouthing him.
Okay. Good enough. Well, thank you for that update.
Yeah.
This is one thing I didn't mention is that this is one sweet young lady. I know parents may have struggles with them because, after all, she is 13, and that goes against what I said just a moment ago because their behavior sometimes is antithetical to that kind of description. But this young lady has gone through quite a bit, to have to leave mom, to leave home, to leave her teddy bears and whatever else she has surrounding her, to leave the proximity of her grandparents, to leave her school, and to go into a new school. Those are quite a few things to think about.
And in the interim, to be the victim of a state-sponsored kidnapping.
Yeah, right.
I still say we should get Homeland Security involved. I think there's a basis.
You bet. Well,
sure. The end result, they'd cooperate with the DHS, and you will go to prison the rest of your life for being a parent.
You bet. Well, a couple more things I have here. This ought to keep the legislature busy for at least 2 weeks. Since we have a law which says that the best interest of the child is found in maximizing his interaction with both parents, then I believe that we should impose a penalty for any individual who knowingly and willfully interferes or limits a child's fundamental right to maximum time with each parent. In other words, putting up a maxim like that, a definition of what the best interest of the child is, and then refusing or neglecting to enforce it, I think is dead wrong. This would keep the custodial parent from saying, well, the child can't go back, can't go on a visit with you this weekend because grandma's coming down from Minnesota, or the child is ill, can hardly make it to the basketball practice tonight, but certainly couldn't make it to visitation. Well, you see, that's an interference with what statute says is the best interest of the child, and I think that the people who formulate those kinds of insults and deprivations of rights to the child should be warned and should be penalized when they knowingly and willfully disobey. We have a sad situation in which those things occur, but we ought to have something that is meaningful and sufficiently punitive as to make them not happen anymore. Well, that would take a day or two to get that through the House and the Senate, I'm sure. Number 6, I think, is another one that is one of the tricks of now that they don't need the trick anymore now because they're by next Tuesday they'll already be elected or deselected for office, so they don't have to worry about using all of these fancy laws that they wanted to put into place to get tough on crime. And so I say that number 6 should be to repeal the 2,000-foot rule and the associated restrictions and registries. This is going to cost us a fortune. Operate in such a way as to use state funding prudently, targeting the most dangerous. Limit the surveillance to cases in which real children are the alleged victims. If somebody's watching porn or displaying porn of creatures that are not real children, I see that as an evil evil activity, but I don't see it as something that we should be putting people on the registry for. There are a lot of things that go on. And the last one, that this ought to finish off their 2-week session here in getting things warmed up for the legislative session. Lady Liberty is blindfolded. Do you know why? Because she is not a respecter of persons. In other words, she'll weigh the facts of a case and the law that is applicable, not caring about who it is that is rendered the verdict. Lady Liberty is blindfolded, but the jury must not be blindfolded. Let the jury do its job, fully informed as to the law, fully informed as to the penalties that are to be assessed. Right now, they are almost totally blindfolded. Well, I want to turn the mic over to, and the camera over to Terrance here before I talk about Proposition 83, or Jessica's Law in California, because that talks about the 2,000-foot rule in California. They want to outdo us here in Iowa. If they pass on Tuesday Proposition 83, they will have a law that is supposed to be even tougher than Iowa's laws. Iowa's law is totally restrictive, and I think this has quite a bit to say about how California looks at these laws. Let's now turn to our legal expert, the fellow we turn to when we need to know something about the courts. And maybe an introduction of a session we're going to come up with in the coming weeks comes from the American Bar Association, and it's entitled "Including Fathers in Child Welfare Case Decision Making." Sound like a good idea? Difficult to do, to include fathers in child welfare case decision making. Right now, they're basically ignored. You heard Terrance tell a story about how they acted as though he didn't exist. And when they found out he did exist, they still treated him as though he didn't exist. That's the way the system works. Well, let's now turn to Terrance on some other items of interest. Terrance Walker.
All right. Thanks a lot, John. And I am the self-proclaimed judge of the judges here in the state of Iowa, and probably throughout the country, because I don't know of too many other people doing this. There was a gentleman, I believe, out of Chicago whose name was Sherman Skolnick, who recently passed away a couple months ago. I didn't want to talk about this so belatedly, but I wasn't actually. I was taking a little hiatus at the time, so I couldn't do the show to share that. But yeah, he was doing the same thing that I was doing in Chicago, believe it or not. You've heard that name, Sherman Skolnick?
No.
No. Yeah, I was reading up on him not too long ago and tried to contact him, and a couple weeks later he died. It's kind of a ironic situation, but The California people seem to be trying to not only outdo Iowans as it pertains to their 2,000-foot law. It looks like they're trying to head off judicial accountability, because judicial accountability, as some of you may have known or may have been in the know about because of this show or because of reading up on the news, um, has been something that's been taking place. I mean, a movement has been taking place in the state of South Dakota uh, to actually support judicial accountability, because the judges are immune from lawsuit as it pertains to anything they do within their official capacity. Uh, More than 300 leaders of the California court system are supposed to gather this coming week to talk about recent developments in judicial elections. Actually, the meeting is actually should be taking place right now. This is an article from the October 28th, and this conference is scheduled for the 1st through the 3rd at the Hyatt Regency in San Francisco. Judicial Council spokeswoman Lynn Holton said that courts and judges across the country are facing new threats to their judicial independence, and this conference will explore the challenges of judicial elections in some states and how we can protect the courts in California. Speakers will include retired United States Supreme Court Justice Sandra Day O'Connor, who will give a keynote speech on independence of the judiciary at the closing luncheon of the conference on November 3rd. Now, this is the same lady that just badmouthed the whole judicial accountability movement in South Dakota a couple weeks ago in the Wall Street Journal. Now, Houghton said that participants in the conference will include the presiding judge, assistant presiding judge, and chief administrator of nearly all of the 58 county-based superior courts in California. The state's 6 appeals courts will be represented by their clerk administrators, and most or all of the courts administrating presiding judges. California Chief Justice Ronald George recently noted that one example of a possible trend is a measure that will appear on the South Dakota ballot next month, entitled the Judicial Accountability Initiative Law, and also known as Jail for Judges. The measure would eliminate traditional judicial immunity and allow lawsuits against judges found by special grand jury to have abused their discretion during the course of their judicial duties. George told the annual meeting of the State Bar in Monterey earlier this month that although such measures have not reached California, he is concerned that they could come to the Golden State. The Chief Justice said the South Dakota measure originated with the California group that wants to try to pass it in several small states before bringing it to California. He told the bar meeting, "We cannot assume we are immune, and if we ignore the trends that we are testing the limits in other jurisdictions, we do so at our own peril." Topics of the conference include judicial election reform, I should say, the challenges of maintaining fair and impartial courts in the face of recent developments in judicial elections, and attacks on the courts and judicial independence. And let me touch on one subject of this, and that's a comment by the writer in this article, because I think that it's been far too long that this kind of misinterpretation has been going on, and that's the idea that the Judicial Accountability Initiative Law is supposed to allow lawsuits against judges who abuse their discretion. Now, that's a fallacy. There's 6 basic reasons, I think it's 6 or 7 basic reasons why a judge can be either sanctioned or removed from office and subject to suit. And those are clearly laid forth in that judicial accountability law. And I think that it's not only an insult to our intelligence, but it's also an insult to journalism that journalists keep printing this stuff the wrong way. Of course, we wouldn't want any of the judges on the bench that are being fraudulent or that are willfully and maliciously violating the law. Well, these are the kind of things that the Judicial Accountability Initiative law specifically spells out as grounds for not only sanctioning a judge or removing a judge or removing his immunity so that he can be subject to suit. So I think that the journalists need to get it right. Hopefully the state of South Dakota is successful in passing this law, and we can bring it to the other states such as Iowa, California, whatnot, because it's something that we need. Nobody in the land of the free, home of the brave is supposed to be above the law. And we have got a system right now in which judges are above the law, and they do things such as violate the law and do fraudulent things all the time, and they're getting away with it because of this thing that they call judicial immunity, which is derived from the Kingdom of England, which we were supposed to have defeated a couple hundred years ago and started a new country. However, the whole thing, the traditional thing of judicial immunity, seemed to have passed over from there. But even the judges over there weren't immune because the king could sanction them. He might be able to even cut off their head. So, you know, the judges over here, they got it good. So, but that's my whole 2 cents on that topic, John and Don. Did you have any other comments?
No, not from here.
Okay.
No.
All right. Well, I think you wanted some time to discuss it. What was you going to say, though?
Don, did you have something to say, Don?
No.
Okay. Yeah, I think for some reason they're getting shook up. The judiciary is getting shook up because they're looking at the populace and can't understand why they're not behaving like they once did, with utter reverence for the judiciary. Here in Iowa, they built themselves a castle, $30 million castle, and very lovely digs, I would say, to house the Iowa Supreme Court. I think I would support the Chief Justice if she is successful in one of her missions to clarify and to cut down the amount of problems that there are in resolving child welfare cases, and to cut out this committee business. They say that if you look at the physique of a camel was one of those animals that was created by a committee. It really wasn't that necessary. Of all the animals, you know, you can usually look at an animal and see, like a cheetah has feet that are fit for running. You know, each creature is uniquely designed by God to function a certain way. The camel doesn't seem to be functional for much of anything except spitting at you. And he sure has a strange-looking back, which I don't understand. But you see, that's because he was invented by a committee. That's so it says.
Where did you get that one at?
Okay. I told you that Proposition 83 is this particular message on the internet was a fact sheet for voters. It says Proposition 83 is called Jessica's Law, aims to become the toughest sex offender law in the nation by enhancing punishment and control measures of sex offenders in California. The initiative seeks to impose strict residency restrictions on all known sex offenders and require lifetime GPS supervision of all registered sex offenders in the same state. Its proponents encourage a yes vote, stating that California kids deserve the protection of its stringent provisions. Also, you can put it on your resume when you go to the polls next time for re-election. Say, I voted for the toughest child abuse law that you can imagine. Although several organizations have voiced strong opposition to the law, including the California Coalition Against Sexual Assault, a group of 84 rape crisis centers and sexual assault prevention programs, and the California Attorney for Criminal Justice. The political interest in tough-on-crime measures has prevented thoughtful discussion on the efficiency or efficacy, the cost, and realistic consequences of if the initiative should pass. You see, who really cares? If it's tough, who cares if it's effective? Is what this paragraph is saying. Given the serious nature of sexual offenses and the grievous long-term consequences to sexual offense victims, California voters may find security in the imposition of longer mandatory prison sentences and restrictive long life monitoring of sex offenders. Although it might seem these controls would procure greater public safety for most offenses, for most offenses, sex offenses, to better understand Proposition 83 and its potential impacts on public safety, it's necessary to place the initiative in its proper context. This includes consideration of the known facts about sex offending and the consequences similar laws have had in other states, and the serious impact of Proposition 83 may have if it's passed. One interesting thing I looked at is the references at the end of the article, is that it mentions studies done in Iowa. Well, Iowa wanted to be the toughest state. And in the Iowa political ads, and of course you probably got sick and tired of political ads, whether you're watching this on Sunday awaiting Election Day or whether you're watching this on Wednesday evening, with a sigh of relief that you probably won't get any more ads right away. The people saying, I voted for tough laws. Well, these tough laws came at a tremendous cost, and nobody cared about the cost because it fit in real well into the profile of the candidate that he voted for tough legislation. And it's imposing some major restrictions on people. According to the U.S. Justice Department, each year there are 60,000 to 70,000 arrests on charges of child sexual assault in the United States, and of these, only about 115 are abductions by strangers. Approximately 90% of all child victims of sexual offending are known to the perpetrator. The perpetrator is not a stranger to the child. Proposition 83 addresses the infrequent situation in which sex offenders is not known to the child. Electronic GPS monitoring may be useful for a limited number of high-risk population of sex offenders, and the California Department of Corrections and Rehabilitation currently uses GPS supervision of serious sex offenders in pilot programs throughout the state by requiring all felony sex offenders to wear electronic monitoring anklets for life. Proposition 83 will effectively hide the most dangerous offenders among the masses of offenders under supervision. Well, we're running close on time here. Don, would you pick it up at that point where it says there are approximately 90,000 registered sex offenders?
In California, Proposition 83 does not clearly state whether it will apply retroactively, thereby requiring electronic monitoring of all current sex offenders at a high cost to taxpayers. Lawmakers will have to clarify the law with a two-thirds majority vote should it pass. Residency restrictions for sex offenders are already required pursuant to Welfare and Institutions Code Section 3003, Paragraph G, Paragraph 1. A sexually violent predator and a serious paroled sex offender cannot live within 1/4 mile of a school, and a high-risk sex offender cannot reside within 1/2 mile of a school, daycare center, or any place where children gather. After implementing residency restrictions, The statewide prosecutors group in Iowa has urged their repeal because they impede the state's ability to manage sex offenders. The residency restrictions in Proposition 83 are problematic for three important reasons. Non-registered offenders are often forced into homelessness, thus becoming destabilized, more likely to offend, and more difficult to track. In other words, the government is creating more hardships on people, which results in more problems. Leave it to the government to create more problems. Police experience shows that residency requirements often result in the disappearance of offenders due to homelessness, limiting the ability of the police to effectively supervise sex offenders. Residency restrictions force offenders out of urban centers and into rural and suburban areas where smaller police forces, limited treatment and social programs, and scarce housing options make rehabilitation and supervision more difficult. Among sex offenders, pedophiles who molest boys and rapists of women are among those most likely to recidivate. Proposition 83 applies to all registered sex offenders, casting the same net over the most serious offenders and those who are amiable to treatment or unlikely to recidivate despite limited resources and staffing. CDCR has only 52 specially trained parole officers to supervise 2,000 high-risk sex offenders. This means that each specially trained officer is responsible for a caseload of approximately 40 to 1. Proposition 83 will
Exacerbate.
has already this already difficult situation. How are we coming on time, John?
Okay, go ahead. Got another
Studies
30 seconds.
in Colorado indicate that offenders who recidivate do not live closer to schools or child care centers than non-recidivists, but that positive social support significantly lowers recidivism rates and rule violations. Proposition 83 will foster access to positive support. On the contrary, social support may be challenged by residency requirements, as officials would be restricted from living with family who live within restricted zones.
Okay, let's. Here's a couple of numbers that may be of interest to people who are having difficulties with the Iowa Department of Human Services or the juvenile court, or you might just like to discuss some of these things that we've been talking about on this program. You might want to be watching over what's happening in the General Assembly, who meets in January, starts another session working on some of these laws. I trust that they will have sense enough to work out laws that work instead of working out laws that will help them win the next election. We'll see you next week.